Hello everybody, I am Tanya Pandey and you're watching Courts This Week on Live Law. Every week I come back with the most recent judgments from courts across India. So subscribe to Live Law if you haven't already and don't forget to click the bell icon. As always, let's begin this episode with judgments from the Supreme Court. The Supreme Court has directed the State Election Commission in Tamil Nadu to conclude the entire process of the local body elections in the 9 newly carved districts by 15 September 2021, including publication or notification of election schedule and the result of the elections. A bench of Justices Hemant Gupta and Anirudh Bose was hearing a miscellaneous application in a plea wherein the Supreme Court had previously directed the state in December 2019 to delimit the 9 newly constituted districts within a period of 3 months. However, the state had taken more than 18 months to conclude the same and sought for 6 more months to conduct the election. The Supreme Court has held that peas and pulses, which were imported in violation of the notifications of the central government and the Director General of Foreign Trade (DGFT), issued under the Foreign Trade Development and Regulation Act, are liable to absolute confiscation under Section 125 of the Customs Act as prohibited goods. The court granted a relaxation by allowing re-export of the goods on payment of the necessary redemption fine and subject to the importer discharging other statutory obligations. Through an earlier round of litigation before the Supreme Court, in the case of Union of India versus Agricas LLP, these imports were held to be illegal and in contravention of the notification issued by the DGFT, and the intention of the importers were also observed to be not bona fide. Accordingly, the Honorable Supreme Court directed the customs authorities to adjudicate the matter under the Customs Act 1962. The Supreme Court has said that it will not interfere with the decisions taken by the CBSE and ICSE boards to cancel the physical examination of Class 12. A vacation bench of Justices A.M. Khanvilkar and Dinesh Maheshwari dismissed a bunch of petitions which challenged the cancellation of exams, observing that the decision was well informed and was taken at the highest level to protect the welfare of over 20 lakh students. The top court also upheld the schemes for assessment formulated by the CBSE and ICSE, observing that they were decisions of experts in the field on which there cannot be a second guess by the judiciary. The bench said that there should be a finality to the status of exams as uncertainty was affecting the psychology of students. In a relief to MP Navneet Kaur Rana, the Supreme Court on 22nd June stayed the Bombay High Court judgment which had set aside her caste certificate. Since she had won from a seat reserved for the scheduled castes, the High Court judgment could have affected her election to the Parliament. She had contested the election by claiming to be a member of the Mochi scheduled caste. A vacation bench of Justices Vineet Saran and Dinesh Maheshwari stayed the operation of the High Court judgment while issuing notice on the special leave petition filed by her against the High Court judgment. The bench asked if the High Court could have made such factual finding under Article 226 of the Constitution. If at all the High Court was dissatisfied with the findings of the Scrutiny Committee, it ought to have remitted the matter to it for fresh consideration, the bench suggested. The Supreme Court has adjourned by 3 weeks the hearing on an application filed by A.G. Perarivalan, who is serving life term in the Rajiv Gandhi assassination case, for interim bail. The bench of Justices Vineet Saran and Dinesh Maheshwari adjourned the matter on the basis of a letter for adjournment circulated by the petitioner. The interim bail application was filed by Perarivalan, citing the stalemate over the lack of final decision on the recommendation made by the Tamil Nadu government to release him from prison after remitting his sentence. In 2014, the Supreme Court had commuted the death penalty to Perarivalan and 2 others to life imprisonment on account of long pendency of his mercy plea. The Meghalaya High Court was dealing with a PIL concerning orders issued by the state government making vaccination mandatory for shopkeepers, vendors, local taxi drivers, etc. before they can resume their businesses. The issue before the court was whether vaccination can at all be made mandatory and whether such mandatory action can adversely affect the right of a citizen to earn his or her livelihood. The High Court held that mandatory or forceful vaccination does not find any force in law and hence are to be declared as ultra vires ab initio. To ensure that people have an informed choice with respect to vaccination, the High Court issued a slew of directions to the state government in respect of the vaccination of all shops, establishments, local taxis, etc. The Calcutta High Court on 17th June had extended police protection to an elderly couple by directing the son and daughter-in-law of the couple to vacate the residential premises immediately. The elderly couple had submitted before the court that the presence of the respondents posed a risk to their safety and hence prayed for relief. On 23rd June, while disposing of the writ petition, Justice Mantha appreciated the prompt action taken by the Bankura Sadar Police Station in securing the safety of the petitioners and permitted the police personnel to take any further action as required in accordance with law. The Bombay High Court on 21st June granted 4 weeks transit anticipatory bail to journalist Rana Ayub in the FIR registered by the Uttar Pradesh police over her tweet on the Ghaziabad incident relating to the assault of an elderly Muslim man. A single bench of Justice P.D. Nayak ordered that protection can be granted to Ayub for a period of 4 weeks to enable her to approach the appropriate court to seek appropriate relief. In the event of arrest during the period of 4 weeks, the applicant can be released on executing a PR bond of Rs 25,000 with one or more sureties, the bench ordered. The Delhi High Court has refused to stay the Competition Commission of India's inquiry against WhatsApp's new privacy policy. A vacation division bench of Justices A.J. Bhambani and Jasmeet Singh was hearing an appeal by WhatsApp and its parent company, Facebook Inc., against a single bench order declining to interfere with CCI's investigation. Appearing for WhatsApp, senior advocate Harish Salve informed the court that they had been served with a notice by the CCI on June 4th to provide information as sought by it on a questionnaire for its inquiry, and that the deadline to provide the same was getting over the following day, and that in the absence of submission of such information, WhatsApp might be slapped with a statutory penalty. Refusing to get into the case's merits, especially since the matter is pending before the bench of the Chief Justice, the court re-notified the case for the roster bench. The Karnataka High Court on 24 June restrained the Uttar Pradesh police from taking coercive action against Manish Maheshwari, Managing Director of Twitter Communications India Private Limited, pursuant to the notice issued to him under Section 41A of the Code of Criminal Procedure in the Ghaziabad FIR. The Twitter employee was asked by the UP police to appear before Loni Border Police Station in relation to the investigation on the Ghaziabad video issue. A single bench of Justice G. Narendra passed the interim order in a writ petition filed by Maheshwari under Article 226 of the Constitution of India, challenging the UP police notice. There will be an interim order restraining the respondents from initiating any coercive action against the petitioner, the bench stated in the order. A division bench of the Kerala High Court, while invoking its plenary powers under Article 226, directed for a re-investigation in the murder of a migrant worker after finding out that the previous investigation was a farce to incarcerate a fellow migrant worker. Appellant Sanjay Oraon challenged the order of the Additional Sessions Court, convicting and sentencing him for causing the death of his friend Hafizul Muhammad. Both the accused and the deceased hail from the Jalpaiguri district in West Bengal and were employees at a furniture and woodcraft industry. The prosecution had proceeded against the accused on the ground of last seen together theory, motive behind the incident, and recovery of his pants with the deceased's blood group to establish an unbroken chain of circumstances. The appellant had submitted that motive alleged was flimsy and not proved. It was also argued that the sub-inspector of police, on getting information about the crime, did not visit the spot. Moreover, there was inordinate delay in registering the FIR, and the prosecution had failed to prove the connecting links in the chain of circumstances pointing to the guilt of the accused. Consequently, a re-investigation without placing any reliance on any of the facts collected in the earlier investigation was ordered to serve the ends of justice. With that, we've come to the end of today's episode. Thank you for joining me. I am Tanya Pandey, and I will see you again very soon. Have a lovely week ahead.
Subscribe to our channel and press the bell icon to never miss a video from Live Law.